If a person seeks legal representation for a court case, and every attorney he or she tries to hire refuses to represent him or her, can he or she receive a fair trial? That depends upon how you define fair trial. Some people mistakenly believe that in the United States, every litigant is guaranteed representation by an attorney in any lawsuit. This is not true. Defendants in criminal cases that involve the risk of substantial jail time are entitled to appointment of counsel free of charge to the defendant if the defendant so desires. In some jurisdictions, a parent is entitled to appointed counsel if the state petitions to terminate that parent's parental rights. There is no right to appointed counsel in civil cases. So there is no right to appointed counsel in divorce actions or personal injury actions or other cases that do not involve serious jailable criminal charges. So if you were to claim you could not find any lawyer to represent you and help you in your lawsuit, you could not claim that your rights were somehow violated. It could be said that you received a fair trial even if you were unable to find a lawyer to represent you at trial. But if the case was a complex one, and one where a knowledge of the laws and or regulations as well as the procedural rules of court apply, that makes the difference between winning and losing. Having no attorney to represent you doesn't make it a fair fight. But still, that may be unfair but not illegal. You have no legal recourse in those circumstances. I have met people who have claimed that they cannot find an attorney to represent them in a particular civil action. More often than not, the reasons why are fairly clear. Either the person seeking representation can't afford to pay the attorney and or the person doesn't have a winning legal argument, either because the person is clearly in the wrong or because that person doesn't have enough evidence to win or win in the manner that person desires.